In all criminal prosecutions,
the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed,
which district shall have been previously ascertained by law.
The Sixth Amendment really is the centerpiece of our criminal justice system. It is the amendment which most fundamentally guarantees the right of trial by jury. But it doesn't merely guarantee the right of trial by jury. It guarantees the openness of the proceedings.
The trial is going to be a public trial because the public has a right to a public trial. The press has a right to be there. The people have a right to be there. The idea is partly defendants' rights, but it's partly about self-government. Even if the defendant prefers to be tried somewhere else, no, he's going to be tried where the blood spilled because that local community has a right to weigh in.
And to be informed of the nature and cause of the accusation.
to be confronted with the witnesses against him,
to have compulsory process for obtaining witnesses in his favor,
and to have the assistance of counsel.
the assistance of counsel for his defense.
The colonists experienced the inconvenience of trial, the humiliation of trial, of criminal charges being brought in any manner to prevent insurrection, to act as a consequence for those who spoke poorly of the king or who worked against the actions of the soldiers or the actions of the government. These protections in the Sixth Amendment were put in place to prevent those types of negative consequences.
By an impartial jury.
An impartial jury of the state and district wherein the crime shall have been committed.
On its face, what the Sixth Amendment says is that you have a right to an impartial jury and that the jury has to be selected from the area where you live. But that's been interpreted over time to mean that you have a right to a jury of your peers. That and the Due Process Clause together means that the government can't exclude groups of people from the jury, either on the basis of race or gender. You know, for a long time, women were excluded from jury service because they had obligations at home. They couldn't take time off to be on a jury. And eventually the Supreme Court realized that women couldn't be excluded from the jury. It wouldn't be a fair and impartial jury.
And to have the assistance of counsel.
The assistance of counsel
for his defense.
At the time the Constitution was written, you had a right to the assistance of counsel, but nobody was going to pay for a lawyer for you. So if you could afford a lawyer, you got one. And if you couldn't afford a lawyer, then you didn't have one.
Back in the 1930s, we had the Scottsboro Boys, and they were known as the Scottsboro Boys because these were black boys who had been arrested on false charges of rape in Scottsboro, Alabama. And these boys, a group of boys, were tried in one day, sentenced to be executed, and they did not have an attorney. They did not have an attorney. And that case was appealed to the U.S. Supreme Court. And the U.S. Supreme Court said in a case involving life or death, you must have an attorney.
Until 1963, in the case of Gideon v. Wainwright, the Sixth Amendment was interpreted to mean that only if you were accused of a capital crime, a really serious crime, were you entitled to this assistance by a legal counsel. The breakthrough in Gideon v. Wainwright, and it's really a remarkable story. Gideon was an impoverished pauper who really constructed his own legal defense and greatly expanded the right to legal counsel to a right enjoyed by anyone accused of any crime, no matter how minor.